Well, Dr. Shapiro, as Rabbi Schachter points out, the conservative movement has spoken of equality. They teach it in the Solomon Schechter day schools. Yet you find that there's something wrong with what? What aspect of it? Ordaining a woman or mixed seating or what?
Let me take that from three different views. The first is the sense in which you're using the word equality. Me, it is not equality for me as a feminist for you to tell me that I will be when I do what you do, and that what I do is not important. Those things which have been women's in Jewish tradition are looked on in Jewish tradition as equally important. They are reasons that women have been excused from certain other obligations in the same way that, for instance, someone who has lost a loved one is excused from certain obligations because the things that they are doing are very important. What you're telling me is that what I do is not important, but what you do is so important that I'll be equal when I do the same thing. This message has been beamed out from the seminary. It has been beamed out from the establishment of the conservative movement. And I find that when I go places and speak, women come up to me, and I get floods of letters saying, we were waiting for someone to say that. We feel so put down by what they're doing, by saying this is equality for us, that they give us no credit for anything that is ours, but rather say when we take on those things as men, then we'll be equal. We feel we've always been equal. But this sense of bandwagon, this is it, this is the feminist challenge. I don't believe, I'm a feminist, I don't believe the feminist challenge is as it's described. I believe the feminist challenge is to give me some sense of worth in myself as a woman and in those things which Judaism says that I do. And I have found a tremendous response from women all over the country who feel this way and are upset by this message being beamed out that they're not quite so good. And I must tell you, I don't think we're divisive, because it's really these people, the message that the Union for Traditional Conservative Judaism beams is enabling some of those people to stay within the movement. Many of them have said, we're the only voice within the movement, the one we're getting from the seminary today, we would leave. If there is any hope, it's with you for us to stay. If you succeed, we will stay. We are watching and waiting.
I'll respond to your question, but at the same time I'd like to respond to something that was said before. I think in much, all of us, I think, have had the tendency amid the passionate debate over a period of years to fall into some sort of rhetoric. All of us probably have similar problems restraining ourselves from doing that, but one of the aspects of that really is deeply disturbing to me is the notion that is sometimes expressed that it is only those who are opposed to the full equality of women who are really deeply concerned with the halachic issues. In my experience, that is certainly not the case. I think both on a personal level, I think that's inaccurate, both on a personal level and on an institutional level. I, for one, did not begin my odyssey into full ritual equality for myself as an individual Jewish woman until I had spent a great deal of time studying a whole variety of texts of halachic texts of classical Jewish law to convince myself that this really was permissible. What was not acceptable to me was to listen to the answer no from someone who had not yet conducted that study. And if I could not find enough leaders who would conduct that serious study for me, I, for one, and there are other women among my colleagues at the rabbinical school at JTS, who went ahead on their own to undertake a very serious study of the text and to see, is there sufficient flexibility within this material to justify the move that we consider now to be an ethical imperative given the society in which we live. But so the question really is not seriousness about Jewish law or no seriousness, but how exactly do we interpret those texts? Now, the example that you raise is really a very good one.
I didn't mean a bris, because you don't need a woman for a bris, but
that's right. But the woman serving
right.
as a witness, which is involved with a woman signing a ketubah,
right.
supervising divorce or conversion proceedings, is all would agree, all of the faculty, those who voted in favor of the ordination of women agree 100% with those who voted against, that the issue of testimony is a very serious halachic issue. It's perhaps the hardest nut to crack. And yet, so if you're asking my
what are you going to do?
My personal view, is that the halakha can permit, although this was not a normative position in the past halakhic, the past history of the halakhic tradition. I do believe that that the halakhic tradition can now be understood to permit women to serve as witnesses, and let me tell you why. The testimony issue is often discussed in very monolithic terms, and as is the case with almost any issue in rabbinic literature, monolithic statements tend not to be accurate. Although it's true that for most issues of testimony, cases in which a person is called upon to offer testimony in the public sphere, women are not permitted to do that according to normative Jewish law. There are a number of individual cases in which the halakha itself, the earliest layer of development of the Jewish law, permits women to serve as witnesses. My favorite, there are a number of different examples of this. My favorite one is the case in which a woman finds herself in the tragic situation in which her husband has disappeared, and there are no witnesses to his death. That woman is then considered by Jewish law to be an aguna, a very beautiful image, literally translated, a woman who was anchored. That is, a woman who is legally married to a man who, in all probability, is dead, and that means she may not go on with her life. She may never remarry. She's neither divorced nor is there testimony to the death of her husband. The Mishnah, the first great codification of Jewish law, a work compiled to the 3rd century, addressed this problem in what today we would consider an extraordinarily radical way. After all, we all know that the Torah requires 2 witnesses to testify to anything, and those 2 witnesses must be men, and they may not be related to each other or to the person at hand. There's a whole set of restrictions. In this case, which, if I might use modern parlance, represents an ethical challenge to what would be the Torah's normal attitude toward a situation, the rabbi simply said anyone may serve as a witness to the death of that husband. If it's a woman, that's fine. If it's one person and not 2, that's fine. That represents to me the rabbi's very high level of ethical sensitivity and their understanding that the law was not monolithic, and that if new situations occur which require a new way of grappling with the situation, the Jewish law has the flexibility to adjust to that. And I'm suggesting that's the sort of argument that we can use today.
So you will be doing it yourself? You will be serving as a witness?
Yes, I believe that's now permissible, yes.
And you think you might have problems from colleagues?
There will be those who will disagree with you.
You think you might have a problem of not being able to co-officiate at a wedding, say? If you were being asked to sign the ketubah.
That may happen. That, in fact, would be a less serious issue than the possibility that I would perform a marriage that would later be questioned. I would always, of course, let my congregants know that there were those in the Jewish world who would disagree with my opinion and engage them in the process of making the decision together.
I'd like to respond to this. The first thing is, I think it's very clear, when you say no one has done a serious study, we know that the great scholar of our movement, of our generation, Professor Lieberman, did do such a study. His 5 top students came to him when this issue first came up and said, please do a study and issue a responsum. And he did do so, and he gave it very serious thought, and he said that it was not legally possible. These 5 top students then, who are the senior members of the Talmud faculty at the seminary, then studied his tshuva and came out publicly in the newspaper and said, we agree with it. These are, in essence, to use again modern parlance, the Supreme Court of our movement. These are the people who know the most halakha and are recognized by everyone as our legal scholars, and the place where the buck ends. To come and say, I'll go to a lower court because I like their decision better, I won't abide by what the Supreme Court says, is one thing. To beyond that say, I've studied it myself, and I think it's permissible, even though all the top scholars who are my teachers have studied it and think that it is not permissible, is anarchy. Now, you'll do it on this issue, someone else will do it on another issue, and I worry gravely about the future of our movement. In addition, you will say that everybody agrees about the question of witnesses, but I have personally done a study, and I've decided it's permissible. And to tell your congregation that, well, there are going to be people who question it, is to beg the question of the fact that the children, as yet unborn, of some of the things that you will witness, such as a Jewish divorce, will have questionable legal status because of this, because the whole world still doesn't agree with what you have decided for yourself, and you are willing to put their unborn children into this situation for the point that you want to make, opposed to all the legal scholars of our movement.